Out of all the hundreds of calls we receive every month, the most common question we receive in our office is, at what time can my child decide where they want to live? The truthful answer to that is 19 years old. As you may know, in Alabama, you're not an adult until you reach 19, and that is the age where a person can decide where they want to live. Up to that point, a person may know where they want to live. They may know what they want to do, but they're still legally a child for a reason, and they don't always know what's in their best interest. And so, although there's common misconceptions that at 12 years old or 14 years old or 16 years old, they can decide. Well, it may be hard for a judge to make a 16-year-old child do anything because they can get in the car and drive, or they can run away, God forbid. The judge will take into consideration what your child wants to do at times for good reason, but they can only decide where they want to live when they're 19 years old as an adult. If you have children and you're going into a divorce trial, you may wonder, can my child testify in my case? Because they've seen what's going on. They know how the other parent treats them. They know what I do for them. Can my child testify in the case? The answer is yes, your child can testify in your court case. You have to determine, do you want your child to testify? Because there may be some situations where it's so stressful on the child to have to do it. Maybe they're super emotional. Maybe they feel like they're going to be pitted against mom or dad if they're in the court case. Can they testify? Absolutely. Do you want them to? Maybe, maybe not. That's something we should discuss to decide what's best for your family. In any court case, you have a right to hear and see all the witnesses who are testifying in your case, and even to know what they're saying to the court. So you may wonder, can my child talk privately to the judge without me or the other parent there? Yes, they can, if both parties will agree. Very, very rarely have I ever had a child who testified in open court in front of both parents because it's so stressful. Most judges really hate having a child testify in front of the parents because they know it is incredibly traumatic to a child to have to do that. So we would probably ask the court to allow your child to testify privately outside of the presence of the parties, even if it's still on the record, and even if the attorneys are there to sit and listen or even ask questions. Your child can testify privately to the judge outside of the presence of the parties if both parents will agree for that. If your child has testified privately to the judge without either parent being present, you may want to know what the child has said. Now, there may be times that you've agreed for the child to talk to the judge, what we call in camera or in the judge's chambers, with just the guardian ad litem or just a court reporter or just a judicial assistant there, without any lawyers, without the parents, and it's just for the judge to get a sense of what's going on in your child's mind. In those situations, you'll never know what the child says. There are other times where the child may testify in front of the lawyers on the record, and the judge may give the instructions to the attorneys to please don't tell your clients what the child has said. That's on the record, so you still have a right to know it. Your lawyer may choose to give you kind of some general synopsis of what was said without the details of exactly verbatim what the child said in court. Or there may be other times when the lawyers are free to tell you what's been said, but you're asked specifically, and it's always a good idea to never interrogate your child, to never talk to them about what did you say to the judge, or my lawyer told me you said these things. Why did you tell the judge that? That puts your child in an unfair position that no little child deserves to be put in. So yes, you can sometimes know what the child says, but I would never encourage you to talk to the child about what was said in court. One point you may want to consider is, do you want your child to testify in your case? There may be things that only your child knows or saw that outside of you, they're the only witness to it. And you may think the judge has to hear from them. But without fail, it can be really traumatic to a child. Even if they know what happened, and even if they're on your side and they really want you to win, they're still having to sit in the same room or even at least in the same courthouse with the other parent who knows they're there to testify against them, essentially. That can be a really hard position for a child to be in. There's recently a case that our office handled where the only witness to a certain event was the child. When that child sat down to testify, she was absolutely traumatized. She started crying. She couldn't control her emotions. And to be honest, I went to talk to the parent and said, hey, she's our only witness that can prove this, but I don't think it's in her best interest to have to testify given how hard it is on her right now. That parent elected not have the child testify, and it was better for the child, even though that parent wound up not winning their case simply because they chose to do what was best for the child rather than what was best for them. That's a selfless decision. That's what parents do every day. We make hard, selfless decisions. And I would encourage you to really think long and hard before you have your child testify in a case. If there are any questions that you have about the age of your child, when they can have a say in where they get to live, or if the judge is going to consider what the child wants, or any questions about whether or not your child should testify in your case, call us today.